Hello, everyone, and welcome to Talk Nerdy. Today is Monday, September 19th, 2022, and I'm the host of the show, Cara Santa Maria. And before we dive into this week's episode, as always, I just want to thank those of you who make Talk Nerdy possible. Remember, Talk Nerdy is and will always be 100% free to download, and that's because I rely on the support of listeners just like you. If you're interested in pledging your support, as little as $1 goes a long way, but at $2 an episode, you can get access to episodes without any ads in them, which is, I think, pretty good deal. If you're interested, all you've got to do is visit Patreon, patreon.com/talknerdy to learn more. This week's top patrons include Daniel Lang, David J.E. Smith, Mary Neva, Brian Holden, David Compton, Dudas Infinitus, Gabrielle F. Jaramillo Gonzalez, Joe Wilkinson, Leonard Prince, Pasquale Gelati, Patrick Flynn, and Ulrika Hagman. Thank you all so much. All right, so this one's a little bit of a different flavor this week, a fascinating topic, and I'm so just thrilled that I was able to sit down remotely still, of course, with the author of a brand new book called Against Progress, Intellectual Property and Fundamental Values in the Internet Age. So I had the opportunity to talk to Dr. Jessica Silbey. Now, she's a law professor at Boston University, and she specializes in a few different areas. She's interested in intellectual property and constitutional law and reproductive justice, equality, law, and the humanities. She actually did her PhD in comparative literature, which I just love. And she was a Guggenheim Fellow in 2018. And we're going to take some time right now to dive deep into this conversation about intellectual property, about kind of what the law says and how social justice sort of plays into that in the 21st century. Because, of course, we're living in a time right now where what people own, who they are, their likenesses, their content is more and more readily available. And of course, it's more and more confusing to understand all the legal ramifications around that. So I thought this would be a fascinating journey. I learned a lot from Dr. Silbey, and I hope that you do too. So without any further ado, here she is, Dr. Jessica Silbey. Well, Jessica, thank you so much for joining me.
I'm so glad to be here.
I'm excited to talk all about your new book, Against Progress, Intellectual Property and Fundamental Values in the Internet Age. And before we dive into this, I think, incredibly important topic, as I often do, I like to get a little feel for the background of the guests that I'm working with. And just offline, we were talking about titles and positions. And you told me that you have a PhD, which is kind of uncommon for lawyers who usually have a JD. Do you have both a JD and a PhD?
Yes, I started actually my graduate work in comparative literature at the University of Michigan and thought I was going to be a literature professor. I wrote and was thinking mostly about actually revolutionary literature and film, thinking about how aesthetic works change politics. And I took a class in the law school there as a crossover class called Law and Literature, and that got me hooked into the law school as well. So I ended up doing both of those things.
Oh, very cool. So does that mean that all of your background before graduate school was in literature? Like your undergrad is also in literature?
Yeah, my undergraduate degree is in comparative literature and French and Russian literature.
Oh, very cool. Okay, is that pretty uncommon?
It's very unusual.
Yeah, I was gonna say.
There aren't a lot of law professors there are more and more professors who have both PhDs and law degrees. Maybe PhDs in history and economics and political science.
Maybe. Yeah, exactly.
Right. But literature, I'll be honest, I never understood why it's not a beautiful marriage, in part because law is all about the study of language and text. But it's really only, law and literature movement is really only since the 1980s, which is when I started.
And how has that actually influenced the type of law that you study and that you teach? How has your background sort of forged a path for the way that you approach your legal scholarship?
Well, I mean, in many ways, but I'll say when you're a teacher and in the classroom and you're asking students to read cases and statutes and constitutions and things like that, we spend a lot of time talking about the words and the history behind the words and who the words were for, audience questions, and all of that is that's what we study and talk about when we talk about novels and film and poems as well. So I bring a methodology to understanding law that comes from my literary background, which I think is intuitive. It becomes intuitive to lawyers, but they don't understand it as a literary practice because they think law is not fiction. But I don't actually think. I mean, fiction means to make, right? To make something, and law is all made up by humans too. I mean, So I think it infects everything I do, or affects everything I do.
It's pretty interesting, this distinction between fiction and nonfiction. I think you see this also coming from where I'm sitting, kind of in the sciences. This idea of nonfiction is somehow truth, and fiction is storytelling. Yet, of course, all the best nonfiction is storytelling, and they're really this idea of kind of constructivism. It's become more and more interesting to me in my academic pursuits in psychology. This idea that sort of everybody's reality really is constructed, and although we're all working towards a kind of consent of, or not a consent, what's the word I'm looking for? Like
consensus.
Consensus. Thank you. Of what truth really is. There's your own life, your own experiences really make what is true to you. And of course, we're seeing that deeply in our political landscape right now in America.
Oh, for sure. I'm reading actually this book called The Constitution of Knowledge, A Defense of Truth by Jonathan Rauch. And I don't know if you know about it, but it's all about how consensus is built towards a truth in different disciplines. And he uses the U.S. Constitution as a model for a structure through which we argue about what is knowledge, what is true. And he says that the process of contestation, which one sees in the science through experimental studies and verification and falsifiability and stuff like that, is part of how we develop political consensus as well. It's a really interesting book. I think a lot about it when I think about like what are facts,
Yeah.
stuff like that.
It's such an important kind of philosophical, not just philosophical, but practical exercise, because I think I see this a lot, and I know I'm going very off topic, but we'll come back, I promise. I see this a lot in the sort of scientific skeptic community, which I'm a part of, which is kind of this view of critical thinking, rational thought, evidence-based thinking, evidence-based policy, that sometimes there becomes almost a snobbery, almost a kind of hardlined view that, oh, well, we have a lock on reality and on truth, and the scientific method is the only method. And I think people can kind of work their way down this logical positivist path that's a little bit dangerous, that like, unless it's falsifiable, unless it's this, like it cannot be called truth. And I don't think that's always the case. Not everything is subject to scientific inquiry.
Yeah, no, for sure. That's absolutely. I mean, moral questions, for example. I mean, if we think about the recent decision from the Supreme Court on Dobbs, whether a fetus is a human life worthy of protection under the Constitution is neither true or not. It's not falsifiable in any way, but it's at the center of our political debate right now. Maybe. So, yeah. So, I mean, there are all sorts of important phenomena that we have to debate and come to some consensus about. Whether they get the status of truth or not is a different question, I think.
For sure. And of course, there's, I think, some crossover. I know this is it was a bit of an aside, but some crossover with the work that you've been doing in your writing. You've written two books you've written one book previously. This is your second book, right?
This is my second monograph. I have other co-edited and co-authored volumes, but this is my second monograph. Yeah.
And of course, this is a book for kind of public consumption, right? This is not an academic book. This is a trade book. And the title is Against progress. So, I'm curious. Obviously, we're going to be talking about intellectual property. We're going to be talking about the internet. We're going to be talking about, who owns what is just, how can we have equity, privacy, all of these issues. But I'm curious about the title itself, Against Progress. What were you getting at with that? How did you come to that?
Sure. Well, the U.S. Constitution grants the U.S. Congress the power to promote, quote, progress of science and the useful arts in the first article, which, but by granting copyrights and patents to authors and inventors. They put that in it's in the body of the Constitution. So promote progress of science and the useful arts. It's there in 1789, and the first copyright and patent statutes were passed in 1790, the next year. So there was an idea of progress at the founding of the United States. But it's not well defined at all. It's not, there's no good history behind that word. The debates around that clause don't have a lot of backup. And we being lawyers and lawmakers, have operated from the assumption that that word progress of science and useful arts means means an aggregation of science and useful arts in the embodied copyright and patent. It was an accumulist view of progress without any distributional evaluation. So just accumulate as many copyrights and patents as possible, and the science and useful arts will promote, I think, the social good. And I argue that idea of progress, whether that was the one people were actually thinking about or not, is not what social welfare is today or what it needs today. And so I'm against an accumulist view of intellectual property as promoting progress of science and the useful arts. That's
right,
what the against is.
That accumulist view is almost necessarily just by virtue of the way that our social structure is built and our economy is built in this country. If you have just an accumulist view, who's going to end up accumulating? The people at the very top, the haves.
Right. So that's of course what I think is obvious as well, but it is not the way when you're developing policy and thinking about writing rules. It is the most neutral way forward for many people is to just let the market deal with how to distribute whatever
That's
that
so
means.
Scary.
Yes, very scary. And so and intellectual property law is a form of regulation. It interferes with a quote unquote free market. So there's something counterintuitive about it. But right, just a total utilitarian view of intellectual property does not account for any form of equitable outcomes.
It's so interesting to me, and maybe it's just because of like the era in which I was raised, or the fact that my sort of politics and ideologies are so built into my identity, really, that this view of kind of free market capitalism, that there's some sort of ideal of a market with no intervention, that's even something that's ever discussed as as a goal or as part of reality. Like, I was always under the assumption, and of course I'm not an economist, right? I'm training to be a clinical psychologist, and my background is in neuroscience. Like, these are the disciplines that I came from. But I was always under the impression that in order for capitalism to work, in order for there to be a market at all, it has to be regulated. Like, that is fundamental to capitalism.
Well, I mean, so it's always a question of what kind of regulation. I think true libertarians would talk about criminal law, would talk about fraud, a form of fraud, very bare bones that focuses on individual behavior, not structure, right? Not institutional mechanisms. But I'm with you. I think there's no freedom without regulation. That's the way I think about it. And, not only freedom from other people's assault, but freedom from driving too fast, freedom from, I think, very harassing situations. I mean, so I am with you. But it's a very self-serving argument, free market capitalism, as you said at the beginning. I mean,
it's only self-serving that's the weirdest thing about the American political landscape too. I remember I was talking to one of my friends from the Netherlands recently, and he was like very confused about a lot of decisions that Americans make. And he was like, why do people vote this way? Why do people want this? I'm just very confused. And I was like, you've got to remember that not only is it self-serving here in America, it's self-serving for the elite, but there's this weird assumption because it's like baked into the American idealism that one day you will be elite,
right?
Know? So you don't want.
It's also built into an identity about America, which is part of manifest destiny, part of sort of the idea of individualism and individuality. I mean, even that you were just talking at the beginning about individual truths or collective truths that may go against dominant truths, for example. The whole idea that one can form one's own community with your own truth is quintessentially American, actually. And it's this idea of going against the grain, going your own way, being free to do that. I think wrapped up in this is this idea of the individual versus the collective. And I mean, if we're back to the Constitution is all about individuality. And I mean, it's promoting progress of science and useful arts by granting rights to inventors and authors, individual people, not companies, not organizations. This idea of the heroic inventor and the romantic author was at the core of that clause.
Which is interesting. And again, this is going to take a little bit of a turn, but it's interesting that a lot of, and obviously correct me if I'm wrong here, but a lot of precedents that have been set since then actually involve viewing large aggregates of people that are headed by boards or headed by individuals, the same sort of purview and the same rights as individuals.
Yeah, you're talking about Citizens United, right?
Yeah, and Citizens United from a voting and from a funding campaign perspective, but also from a property or an IP perspective, right? Like I've known many people who they developed things, they invented things, they created and authored things while working for a company. And when they left, that stayed at the company. The company owned the thing they made.
Right. That is, I mean, this may sound like I'm contradicting myself, but that is almost uniquely American also in Europe, that work for hire doctrine. That's what it's called if you're an employee and you make or invent something within the scope of your employment. It belongs to the company. And that's this idea that the company has invested in you and invested in the materials. And because they've invested all this risk and resources, they should own what they make. It's actually the same kind of model about individuality and bootstraps and making your own way. And I think one of the fundamental problems with that model, not only the work for hire model, which I think can be justified on other grounds, but this idea that companies are just like people, but they're just groups of people, is that it mistakes all what we understand to be about the transformation when an individual becomes a member of a group, how groups behave differently, how groups interact differently with other groups. Like groups are not just collections of individuals. That's just not the way they behave. We have whole disciplines devoted to understanding organizational behavior, sociology, for example, anthropology, where the community and the collective understanding and behavior is different from each individual. But the United States ideology is that companies are just collections of people.
Absolutely. Oh, it's fascinating to think about. I'm just realizing too that the very podcast you're on right now, it's called Talk Nerdy with Cara Santa Maria. And that's because, gosh, I don't even know, 7-8 years ago when I was working at the Huffington Post, or maybe 10 years ago now, I was the science editor, the senior science correspondent, that was my title, at the Huffington Post. And I developed a web series with Ariana called Talk Nerdy to Me. And it was like this, I think, weekly, gosh, I can't even remember, video series that we made in the studios there. That was kind of the bulk of my job. And so when I left HuffPost, they were like, oh, no, we own this.
Yeah.
They were like, it may be your name. It may be that you designed and developed everything, but we own this. So when I actually launched my podcast, I called it Talk Nerdy, not Talk Nerdy to Me. Just out of an abundance of caution, because I was worried about spinning it off, even though people knew the name and identified that name with my work. And I wanted to have something that I continued forward that was similar. I didn't use the exact same name because I was worried that I would get sued.
Did HuffPost get upset with you?
They didn't. Luckily, nobody really followed up or said anything, but there was a true concern, and I consulted with a few people, and they're like, "Better safe than sorry."
The trademark lawyer in me has all these bells going off for sure. Yeah, yeah. Talk Nerdy to Me and Talk Nerdy are not so different that an audience wouldn't be confused as to
exactly.
The source. Yeah.
But they're different enough. Talk Nerdy to Me and Talk Nerdy with Cara Santa Maria, which is the technical title, are definitely different enough from a copyright perspective, I think.
Right. Well, but what that story is so interesting to hear. What that story brings out is what is often a contemporary conflict now among creators and innovators, which is when your identity is baked into the thing that you've made, whether it's a patent, for example, and your name is on the patent, or it's an authored book and you're the author, or you've made a movie and you're starring in the movie and it's your face all over the advertisement. Whether when someone else has the rights to that work, whether your identity and your persona is actually sort of captured through the property regime in another person or entity's asset base. It can be very offensive and upsetting for the creator and innovator, but the right of publicity or the right of controlling one's identity is something that's actually become much more important in the digital age, and it's often takes a back seat to more classic intellectual property rights.
But you're right, it's so important, especially now. And I guess we're probably going to start seeing a lot of these conflicts coming up in court cases, even just within the last 5 years, where influencer culture has become the way that a lot of individuals are monetizing their work. I think back to when I was working a lot more in television. And so it's not just your identity, but your likeness, because so often when you're signing contracts, right, it's basically we own your likeness now. We have film, it's your face, it's your voice, but we can do with it whatever we want. We can change it, we can alter it, we can make you say stuff you didn't actually say. This is so common if you're doing a documentary, for example, and we see people get burned this way all the time. But I'm remembering doing a story for I think it was USC's Institute for Creative Technologies, and we were talking about, and then Industrial Light and Magic, and we were talking about these really cool new developments, scientific developments in digitally capturing an individual's likeness and then overlaying it over animation. So kind of the way that a lot of movies are made now. But back then it was Avatar and Benjamin Button and Maleficent and all of these things. And it's what happens when the person dies? Are you still able to use their likeness and make them say things that they didn't say in life? And that big Tupac, do you remember the big Tupac hologram?
Yeah, these are active lawsuits right now.
Right, actually. They are. They're still active. Okay, so this is a fascinating area, right? This almost takes a lot of what you write about to an extreme, not just the art, but the artist itself is sort of being contended with.
I mean, the CGI created identities, whether it's Carrie Fisher in Star Wars, after she died, or Audrey Hepburn in some new advertisements she's been regenerated. These are all questions about whether heirs. I mean, when you die, you don't have any right of privacy anymore. Privacy dies with the person, but property rights do not die with the person. And insofar as persona and likeness are property rights under the right of publicity regime, they can be inherited by heirs or companies that are holding companies for your likeness, like movie companies, for example. And right of publicity is right now a state by state regime. There's no federal law. So depending on where you die, depends on whether the right of publicity extends beyond your life, and people monetize it. So to this point, there's a case before the Supreme Court right now about Andy Warhol's print poster, they're art posters, prints of the artist Prince, the musician Prince. And Andy Warhol made these fabulous portraits of the musician Prince based on a photograph that was made by Lynn Goldsmith on behalf of Vanity Fair years ago in the 80s. And the lawsuit is actually between the photographer, Lynn Goldsmith, and the Warhol Foundation that owns the copyright to Warhol's art. Nowhere is the heirs to Prince, the musician, and anyone asserting Prince's likeness, that there is an interest that, like, who owns Prince's likeness? The photographer claims copyright in her photograph. Warhol claims copyright in his art that was based on the photograph. And absent from this is the conversation about Prince himself, because his rights are nowhere being adjudicated. The same thing is happening. I mean, and I can explain that as a legal matter. But if we're talking about what matters to people, that matters to people. The same thing about, there's also a lawsuit between a photographer named Jeff Sedlick, who made this amazing photograph of Miles Davis, the jazz musician. And then a tattoo artist put a tattoo on a person. She's a famous tattooer, of this photograph on the body of a person, one of her clients. So that her client now has a replica of that photograph, which is Miles Davis's image, on their arm. And this is a copyright lawsuit between the photographer and the tattooer, which implicates whether the person who owns this tattoo, wears and owns this tattoo, can continue to display it from their body. But again, Miles Davis is nowhere being talked about.
Wow, this is it's like so many layers deep. It's so, and again, I'm connecting all the dots in my head because I've worked in television for so many years. I can't tell you how many times I had to get art clearance for my tattoos. So I would be booked for a gig, and then they would say, any visible tattoos that are going to show, we need proof that you own the art. And I was like, what is that even? And I have on my forearm, I have a replica basically of a famous fossil. It's called Archaeopteryx lithographica, the Berlin specimen. And so the way that I always got around it is I would go to Wikimedia Commons and find a Creative Commons license of this fossil. And I would send that to them and say, oh, this is, in the public domain. And they were like, oh, okay, you're cool. What?
Right?
It's what a weird
that's
thing.
Because the tattooer who put the tattoo on your body wasn't claiming copyright in their art, were
Nope.
they?
Nope.
Yeah.
They were just basically doing a tattoo of something that exists in nature.
Right. Yeah, I mean, but of course, if you take a picture of something in nature, you can own the copyright to the picture. But other people can make a similar. I mean, how many pictures of the Eiffel Tower are there?
Exactly.
Right?
So all you do is you find an open access or a Creative Commons license, and you go, no, this is the tattoo of that picture.
So what I talk about in the book is how all of this is just ridiculous. These lawsuits are fighting on the surface about technical intellectual property regimes, as you said, layered, all the different layers. But what I say is at bottom, one of the things that these very odd and very recent, actually, lawsuits are about fundamental values that are being challenged or sort of put to new tests in the internet age, when our identity is all over the place, can be reshaped and transferred, when our reputation is so fragile, and that there are just new concerns we have in the 21st century that the internet has exacerbated, but that are being fought over using IP rights, which is very unusual, actually.
Interesting. And of course, I mean, I think it speaks to the way that, and I'll use progress in a different way, but the way that sort of the progress of time, progression, basically, just movement towards the future, it often takes its form, which is that the policies, the legal precedents, all of these things are always behind the actual innovation, quote unquote, or just creativity of the people who are doing stuff. And especially in an internet age where we're all connected and where everything happens really fast. I mean, one great example of that you do write about is this idea of attribution, just of credit. And I see it all the time. I have a ton of friends who are photographers, like National Geographic photographers and, wildlife photographers, or people who make cartoons or make memes, or they make things on the internet, and then they get shared all around with no attribution, with no credit, and it's like heartbreaking. And like, at what point is that legal? At what point is that just moral? Is it just the right thing to do, or is it actually against the law to
Right.
do?
One hopes that the law reflects contemporary norms that bind communities in meaningful ways. But of course, law is always reactionary. It's always behind the times, as you said. It's just written in the past. That's the fact of it. But I mean, you're right. Attribution is actually age old. I mean, people wanting credit, people wanting to be recognized. These are age old debates, but they are becoming more sort of more agitated today when it's not so hard to find out who wrote that, or like what, the implication of being left off is I think raises people's blood pressure. Like, it suggests that it wasn't hard to put my name on it. For example, I just read actually a really interesting article by a fellow at Stanford. Her name is Sarah Pulse, and she's writing about co-authorship and co-attribution in songwriting. And one of her findings, it's an empirical paper, is that when songwriters give each other co-equal credit, so it's 3 people and they each get a third, for example, as opposed to a different division, which might maybe reflect different forms of equity, equal attribution and credit and profit splits have been correlated to more hits, more popular songs that actually, yeah. So, I mean, that's a sort of there's a virtuousness to that conclusion, obviously. But a lot of bad things happen when you don't give proper attribution or fair attribution. But in patent law, one of the things that makes patent law so frustrating is that people might want to put their coworkers on patents because they worked so hard in collaboration. But if the inventorship on the patent is not accurate according to patent rules, which may not correlate to what we might think about what co-inventionship is as a ordinary way, the patent is invalid.
Oh,
So
right.
there are all these ways that you are disincentivized at times to produce what we might think as fair and true attribution in certain IP regimes.
Didn't we see this a lot with the Elizabeth Holmes case, the Theranos thing? Like, that was one of the ways that I guess regulators were able to get in when everything was falling apart, was that like she was on patents where she had like nothing to do.
Yeah, right. I mean, there's just so many ways. I mean, if you go to the old patent register, for example, before women could vote, like patents have been around, as I said, since 1790. So if you look at patents from 1790 to about 1860, when women were, women couldn't own most women couldn't own property, and married women, property was the property of the husband. There were a lot of actually women and men on patents at the time. But there's new research that suggests that the men are only there, the husbands are only there to validate the women. The women were actually the true inventors.
Right. Yeah.
So these are like inventions for corsets, inventions for forms of washing clothes, for example, things that the men were absolutely not inventing, but you had to have the man on it there to validate the patent in a different kind of way, in a property holding way. I mean, property is just a social construct, right? And so, as is attribution. But intellectual property is something entirely different. And yet we're fighting about these very deeply held views about both property and relationships through the intellectual property system on a regular basis.
Yeah. And it's so interesting, kind of going back to this idea of like who owns what, or like who made what, and how do we attribute. And of course, there's these caveats that we have to pay attention to for patents specifically because of the legal way that those are written. But even just when it comes to like art, historically, art was a tangible object, right? It was fungible. Let's be using the new language, right? So it's this thing that, like, Warhol makes a piece of art, and let's ignore that he's like making a piece of art based on somebody's art. We'll get back to that. But like, let's say he's just creating from memory, not from a Campbell's soup can, a piece of art. He signs it. He puts his name on it, and he's like, "This is mine. I put my name on it. Anybody who has this knows it's mine." But that's not the case with a digital image.
Yeah. Well, Yeah, I mean, Warhol famously played with signatures. His
Right.
name was on it, but somebody else put the name on it.
Yeah, so even my
right.
example is complicated.
He actually tried so hard to fuck with authenticity and the whole idea of originality from the very beginning. So it's a really great example. But think about NFTs. What people are talking about, non-fungible tokens or digital art, and how, I mean, is there an original digital art? I mean, it can be copied ad infinitum, and there's no origin really. And I mean, what it means to, in my first book called The Eureka Myth, I spend a lot of time unpacking the idea of originality, that no art actually has an origin, that all creativity is iterative and and that that the romantic author myth has really perverted the way we think about what good creativity or progressive creativity could be. But I mean, the attribution norms, I mean, so there are a couple ways. So you can think about putting your name on a patent, being named on a patent as a form of attribution. We can think about trademark, like when you said talk nerdy, talk nerdy to me, can be a trademark that designates the source, which is you.
Yeah.
And you can also have the podcast by you, right? But with your name, and that would be an authorship claim. You would be the author. So across all the IP regimes, attribution has a function in trademark, copyright, and patent, but they work differently in each one, which is incredibly frustrating to people who want to resolve disputes that are really based on a claim of fairness or recognition. You just want to be recognized as having participated in this. And all three intellectual property regimes are not about that at all. They're not about recognition. They're about royalties and competition and return on value. So it's a real misalignment, but it's a very, very strong cause of action. Lawyers bring them because they're hefty damages and they're catchy, So there's a lot of things at play in people. I mean, I don't know about you, but I have children, and when they were coming home from school when they were younger, they'd put little C's with a circle around it on some of their artwork, like they're claiming copyright.
Oh my God, how cute.
And I'm thinking, who's teaching them that? Like,
I know, it's like, how cute. And then it's also like, oh my God, how sad.
Yeah, totally sad. It's like they're not coming home and saying, I'm going to invest in securities. Right? So sometimes intellectual property has this popular cultural resonance to people because of attribution. Attribution is so basic,
Yeah.
But it's been extracted in intellectual property regimes to be, I think, distorted in a way that doesn't make a lot of sense.
Well, and again, like how incredibly American, or maybe at this point I should say Western, and just really capitalist, that fundamentally when it comes down to actual litigation, when it comes down to actual claims that are being made, it's about the money, right?
Yeah.
It's about the money.
Yeah, people think money talks. I know. It is. What I like to remind people is that money is important and it matters, but it's rarely the only thing that matters. And when push comes to shove, it's not the thing that matters the most to most people. But it's the thing we talk about. It's quantifiable. It feels like a common denominator. It's sort of like quantitative economics, or just quantitative empirics as opposed to qualitative. It just feels somehow more basic and true when it's just not.
Yeah, I mean, it absolutely reminds me of a big kind of argument that's often made in the psychological sciences. And I often feel like I'm being pulled between two worlds, having come from neuroscience, which is a much quote unquote harder science, and then moving into psychology. And I'm working on my dissertation now, and I'm doing a qualitative dissertation. And it's really hard to explain the value of qualitative research to people who worked in fields. And even myself, when I first joined psychology, I was like, what is qualitative? I didn't even know it existed. And when you kind of compare qualitative versus quantitative approaches to understanding the world, understanding the universe. They're both so valuable, and they both offer something really deep and meaningful that's different that the other can't really offer. But for some reason, we sort of rank order them like, oh, well, quantitative is like real data,
Yeah.
and then qualitative is like fluff.
You've totally triggered a pet peeve of mine. Both of my books have qualitative empirical dimensions, and that's in part because quantitative empirical analyses of intellectual property have dominated the discourse for about 2 decades, and they're just imprecise and inaccurate in ways that are fundamental to understanding how IP works, both in practice and in everyday life. I mean, I'll give you an example. If you do a survey and you count your answers, like you ask photographers, a survey of photographers, do they file their copyright? Do they file for copyright? How often do they register copyright? Do they get royalties on their copyright? Like yes, no, and then a Likert scale of 1 to 5 of how important is your copyright, all these things. You might get answers based on that survey, but if you then interview them, if you have long conversations with them, semi-structured interviews with dozens and dozens that is properly stratified, and then you analyze those interviews for what matters to photographers, how they use their copyrights, the dimensions of intellectual property that matter to them, you're going to get a completely different picture about values and how they work every day. And you're going to realize that the survey is entirely dependent on the questions you asked. And you might have asked all the wrong questions, even though you got, proper p-values and all that stuff.
Oh, yeah, we see that so often with political
Right. Qualitative
polling.
work is fundamentally important for figuring out what the right questions to ask are to understand the phenomenon. But we always rely on quantitative as if it's like the gold star.
And it's sort of my example of that, just a real quick and dirty, is that, I work as a psychotherapist now, and I identify from my orientation as an existential psychotherapist. I use a lot of cognitive behavioral therapy in my work, but I don't identify as a cognitive behavioral therapist. And when a lot of people talk about cognitive behavioral therapy as the gold standard, it's the only thing insurance companies will often reimburse. You have to write your notes to show that you're using these, quote, evidence-based practices. But what really isn't well understood beneath all of that is that the reason it is the most evidence-based is because it is the easiest to study.
Yeah, right.
It is the thing that we can manualize. It is the thing that we can say, let's do this exact same thing to 100 people, to 1,000 people. Whereas the type of work that I do, existential work, is very patient-centered, and you can't manualize it because it's too contextual. It's like, it's very specific to the person I'm talking to, that it's not going to apply to the next patient. And it's like, it's just a fundamental kind of flaw in how we have become, I think, almost too reliant. And again, I am a scientific skeptic, and I love the scientific method, and I love, utilizing really staunch evidence-based work. And I think all policies should be evidence-based, but garbage in, garbage out. We have to have good evidence.
Right. If the only stuff you're studying is the stuff that's easy to find, you're really only getting a very slim slice of the world out there, and it's going to be perverted. I mean, it's understandably what one talks about and what counts as knowledge, and then what gets reified as ideologically true are the things that you study and publish about, which if that's the only thing that's easily findable, low-hanging fruit, we're just repeating the problems of the past. I mean, it is very frustrating. There's something about the academic world, and this is less about law and my book, but more about the world in which I operate every day, which is a university setting, that the push to publish, the push to say something new, the focus on publication over teaching, for example, and the pace at which one is supposed to produce research, I think sometimes has had a perverse incentive on has created some of the problem or exacerbated the problem that you're talking about. How do we measure good scholars, for example, U.S. news reports about like what the best university is, and all this is problematic from the perspective of the public interest in producing knowledge and understanding our world to live in harmony with one another, frankly. But it's a predictable outcome of that kind of metric-based thinking.
Yeah, it's almost like the way that and we're starting, luckily, to move away from it, but the way that we, for example, do college admissions in this country, like, okay, so do we want a bunch of people who are well-rounded and interesting and have a good academic um, value, like somebody who we think is going to flourish in an academic setting, or do we want somebody who takes this one test really well?
Right.
Like,
Right.
and that's the weird thing. It's like we get so tied up in the sort of psychometrics that say this measurement technique is a proxy for reality, that now we rely on the measurement technique and we forget about the reality we're trying to test.
Yeah, the whole idea of testing and merit and questions of um capacity to succeed in school and all that. I mean, when you blow apart all those metrics as, you know, also biased and reproducing forms of systemic racism and sexism and all that stuff, and you say, well, what's the alternative? You know, the radical idea is that the alternative is a much more communal, equitable, social based system that has broader access for more people and less opportunity for hierarchy, which scares the shit out of the people who've benefited from the system in the past, right?
Yeah,
I
and
mean,
it
we're
scares the
talking
shit out
about,
of the people who are actively making the decisions about the
yeah,
system because they're the ones who historically have benefited.
yeah,
Of
they've
course, that's what
invested in it,
happens.
right?
They
I mean,
invested in it, they rose to the top.
it's a radically redistributional idea
Yeah.
of resources that matter in the United States, maybe in other parts of the world too, and you know, people don't want to give up their privilege. You know, that's
No, of
just
course
the way
not.
it
And
is.
of course,
I
it's so
understand that, you know.
And of course, it's so funny because obviously you described at the beginning, Layers Deep, the title of your book, Against Progress. And of course, the very thing that we're talking about is at least the definition that I have always subscribed to of what progress really is, which is more and more voices being part of the conversation, right? When I think of progress in its truest kind of form that I identify with, especially from a political perspective, progressivism, it's really about having the most people involved in the decision making possible.
Yeah,
So that there's a
inclusivity.
diversity. Yeah,
Right.
it's inclusivity, it's diversity. It's we're always going to have the most equitable outcome if the if we have more and more people from varied, you know, positions, whether they're racial or ethnic or gender or socioeconomic or whatever, as stakeholders, as
Right.
decision makers.
Right. I mean, it makes the process more legitimate for sure. It makes it more accountable. All of those are rule of law principles that we say we care about in the United States. So the idea that we wouldn't want it, what it runs up against is claims of efficiency. And, you know, if some people think that efficiency is a dimension of justice, that inefficient systems are unjust, the balance between radical inclusivity and efficient decision making is a really tense one. And I think that a lot of the times that's where I get hung up uh, is is in that balance.
Yeah, and that's fair. I mean, I think it's one of those interesting aspects of almost everything we ever talk about, especially on the show, where it's never binary, right? It's never this or that. It's finding this good place in the middle, a very nuanced and gray place, which isn't easy to do. And it reminds me a lot of a very thing you talk about in this book, which is the balance kind of between privacy and convenience. You know, you if you want full privacy, it's going to be really inconvenient. And if you want full and unfettered convenience, especially online, you're going to have to give up aspects of your privacy. And so where is that sweet spot? And, you know, how do we all agree on where it should be?
Right. And whether we can agree differently at different times, whether it should be easy to change your settings. I've been thinking about as you know, data portability and changing your settings. I bank at Bank of America, for example, but if I wanted to change to Citizens Bank, for example, it's really, really hard to do that. They make it very, very hard to change that. So, like, whether I have freedom to move is one question. Whether I have privacy in my data is another question. And all these companies make it very hard and in their interest to make it hard for me to actually move and protect my privacy, which is in their interest. But sometimes that's actually the benefit of my financial well-being. I mean, it's
Right.
very hard to unpack these things, I think. And I mean, when I get myself, you talked about existential before. One of the things that I think a lot about is not only progressivism but pragmatism. That if we think about, we should be able to make decisions and then return to those decisions months, years later and revise them. That there should never be, in order for the process to be legitimate and accountable, it always has to be open, not only open in terms of inclusive, but open to be revised. And I think,
OMG, do I agree with that? Like,
yeah.
I'm just like, I just want to be like, Second Amendment, Second
Yeah.
Amendment. Like, this is such a difficult thing for I guess in our culture to understand that, like, you're not flip-flopping. You're not, it's not a personal failure. This is what it means to be human, is to reassess and upgrade our views based on new available evidence.
Right. And it's not teleological. It's not always going in the same direction, right?
Nope.
Different times require different decisions.
Yeah.
And so, I think a lot about the inclusivity and openness and flexibility not being about radical instability, but about actually promoting stability, about adaptability. Yeah.
Oh, I love that. And on that note, there's, a million more topics we could be discussing. Of course, we don't want to give away the whole book. So I want to make sure that, and we've barely scratched the surface, but I want to make sure that everybody, again, knows that you can pick this up. It's Against Progress, Intellectual Property, and Fundamental Values in the Internet Age. That, Jessica, before we go, I know we have a hard out in like 5 minutes. So I always close my podcast by asking my guests the same 2 big picture questions. And because of your perspective, both in literature and in law, I'm just going to be fascinated to hear what your answers are. So I'd be remiss if I didn't ask you them. But they're sort of big picture. So get ready if you need a minute to think about it. No worries. All right. So I want you to think about the future. And you can think about the future in whatever context is relevant to you. This could be personal. It could be communal. It could be professional. It could be global. It could be cosmic. I don't care. When you think about the future, the first question is, what is the thing that's keeping you up the most at night right now? Where are you finding difficulty with maybe pessimism, even cynicism? What are you legitimately worried about? And then on the flip side, so that we maybe end on a slightly more positive note, where are you finding your hope and your optimism when we really, really look at this from an authentic perspective, not a Pollyanna perspective? What are you looking forward to?
Okay, well, so what keeps me up at night is the climate crisis and gender inequality. And they're linked, but I don't have to go into how. I very much worry that the kind of way people think, what we've been talking about today, sort of quant-based and questions of radical efficiency, short-term thinking, not qualitative, not values-based, is preventing us from collectively solving the most, I think, catastrophic problem the human civilization has faced.
I completely agree.
And so I keeps me up at night. So climate crisis and our inability to work together and see past, our own lifetimes, and I think what is a deeply regressive move in the United States to put women and gender non-binary or gender fluid or just gender minorities back in sort of the 18th century. Those 2 things are just actually, they're haunting me. What gives me hope, I will say, is the generations below me. So I'm middle age, and I teach students who are in their 20s largely, and I have teenagers, and they're angry and they're activated. Very, very woke, which is, I think, what they wouldn't like me saying that, but that's what they are. And
yeah.
But they're ready to work on all this stuff. They're not optimistic necessarily. They're not hopeful, but they're not tired like I am. And they're not being kept up at night. They're just energized to fight. And, the fight that they see ahead of them may be deeply revolutionary. It may be burn it all down, but at least they're building communities and coalitions and acting as allies in ways that I think is absolutely necessary to at least address some of these problems.
And they're moving the needle. Like, they are the reason that we're seeing change.
So, when I get exhausted and I'm staying up at night because I just don't know whether there's enough time left in my life or whether I have any ideas left, I really am grateful and I'm going to defer. I mean, I think I don't always agree with, I often don't agree with my students. I will say we disagree a lot, but that's part of the learning process. And they teach me a lot, but I think that they are, they are the future. And they're putting values first. And I really appreciate that.
Love that. Well, gosh, Jessica, this has been such an informative and I think really inspiring chat. There's so much more that we could talk about. Hopefully we'll be able to get together again in the future. I'd love to start a philosophy club with you and just talk. That would be so much fun to just talk about important things.
Yeah.
But in the meantime, thank you so much for being here. It really means a lot. And it was really eye-opening.
It's great to talk about these things with you. Thanks for hosting the podcast.
Absolutely. And everybody listening, thank you for coming back week after week. I'm really looking forward to the next time we all get together to talk nerdy.